everyone. I warmly welcome all the respective members, professionals, and participants who have joined us in today's meaningful webinar. I'm C. Aman Rajput, and it's my privilege to serve as a moderator for today's webinar organized by the Committee on Commercial Law, Economic Advisory, and NPO Cooperative of ICAI. On behalf of the committee, I extend my warm welcome to each one of you to the webinar on the topic arbitration and strategy, policy, and economic decision making in involving business environment. The committee focuses on several key areas such as analysis of commercial and economic developments, knowledge sharing amongst professionals, providing inputs to regulators and policymakers, developing and publishing technical guidance and background materials, and creating awareness about emerging professional opportunities for chartered accountants. Through these initiatives like webinars, publications, technical sessions, uh, the committee actively promotes professional development in commercial law, economic advisory, and NPO related matters. With the increasing emphasis on alternate dispute resolution mechanisms such as arbitration and mediation, the role of professionals with financial expertise have significantly expanded. Chartered accountants today can contribute as arbitrators, expert witnesses, financial experts in dispute resolution, mediators, and advisors in commercial disputes. Understanding these opportunities is a crucial for expanding our professional horizons. Now, it is my honor to introduce our eminent speaker for today's session. We are privileged to have with us Professor Veera Raghuvan sir, an internationally respected arbitrator, ADR specialist, and legal professional. He is an institutional arbitrator and ADR specialist, FCI ARB from UK, and associated with several global arbitration institutes. An advocate and independent international arbitrator and mediator, managing partner at Colv Global LLP, associated with multiple institutional arbitration bodies and institutions across the globe. Sir has extensive experience in arbitration and dispute resolution and has been involved in hundreds of domestic and international arbitration matters, covering commercial, financial, and cross-border disputes. We are extremely fortunate to have him to share his knowledge and experience with the members of ICAI today. We welcome you, sir.
Thank you. Thank you, Mr. Aman Rajput. Good evening to all. And I take this opportunity to thank the committee CCLEANC, which has given this opportunity to share a very interesting and most wanted subject, that is the opportunities what the chartered accountants are having in this field of arbitration and mediation. Coming to the talk, what I'm going to have with you for another 2 hours is mostly on the evolving ADR landscape, particularly focusing our country. Second, I also wanted to just share with you the profession, what you all are involved, chartered accountancy and its advantage when it comes to alternative dispute resolution. We also have to understand what are the professional pathways available for chartered accountants. No doubt, with all these, we have to try to build up our practice, and also we need to have some scenarios or illustrations to understand how and what is going to be the opportunities for chartered accountants in arbitration and mediation, which becomes a part of alternative dispute resolution. Having mentioned this, It's a very unique aspect of understanding the evolving ADR landscape. Most of us would be familiar that we always have an opportunity only in the courts, or considering the speciality of the sectors, it can end up in tribunals or other forums. This is a traditional approach for any disputing parties, particularly the litigants, the lawyers, as well as the financial professionals who normally represent the parties in tribunals relating to tax, and also like insolvency and bankruptcy leading to NCLTs. Beyond this, there is a big opportunity available to all of us, including lawyers. Let me begin with a reality which is considered to be a stark reality, wherein Indian courts are much burdened with more than, we can't imagine the numbers, that is around 4.5 crores pending cases. Our population is quite higher, more than 100 crores. When it comes to litigation, 4.5 crores, that means a reasonable percentage of our population is getting involved in litigations, and that too, this statistics says about the pending cases, not the disposed case or which has been gone to actual appeals in some the higher courts. This is a statistic which has to be seriously looked upon and addressed. And when it comes to businesses, no doubt, time is money. Sorry. And if a decade-long court battle is evident in a particular business, which often means a commercial death, this is where we can make a great impact when you try to just take alternative dispute resolution. Per se, generally we can understand alternative dispute resolution as ADR. It is nothing but a mechanism which is not happening in the courts. It is outside the court. It has no rigid procedure. There is very limited scope of court intervention. Still, there is an outcome which can be given by the facilitators, whether it's a mediator or arbitrator, depending upon the parties' agreement, which also might be enforceable. These are much to say about ADR. And now this alternative dispute resolution is no more addressed to be as an alternative. It can very well be taken up as a mechanism which is accepted dispute resolution, authorized dispute resolution, authenticated dispute resolution, and also appropriate dispute resolution. Now, this ADR is considered to be a wide scope and focusing on the lighter part, that is the mediation, which even though it's been given as the second one, mediation is the greatest opportunity what every professionals have to seriously look upon. Coming to this mediation, we have multiple features which has a reasonable impact on the disputes. We have a concept which most of the chartered accountants would be familiar: pre-litigation mediation. Even before going to litigation, or if you are filing a case in the courts or in the tribunals, it is not that always it's been posted before a judge. Now, after the changes which has been brought under the Mediation Act 2023, even though it's not implemented in full, a concept of pre-litigation mediation. If a case has been registered in the registry of the tribunal or the courts, it will be initially dealt with mediation. That becomes a pre-litigation mediation, which is now in our country also is reasonably mandated. But there are multiple sectors. If it is a consumer sector, it is mandated. If it is a corporate sector, it is mandated. If it is going to be commercial disputes, is also mandated. There are multiple legislations which facilitates this pre-litigation mediation. Here, it is nothing but it is a greatest impact on parties, wherein these parties must attempt to mediate before even approaching the courts for certain categories of dispute. Good example, when we file a case in NCLT, National Company Law Tribunal, the registry of the tribunal would refer the matter to mediation. And there are a set of mediators where the panel would be, one among them would be chosen. And they will be entrusted for the case who might have a reasonable time to deliberate on the parties of the dispute and come out with some facilitation on the disputes so that it can be settled. It's not that always it will be settled. There is high possibility of settlement. If there is a settlement agreement can be drafted. If it is not, then a failure report would be given and the matter would be referred back to NCLT, and the NCLT members would handle those cases and provide a decision on it. This pre-litigation mediation mandate is the greatest future which we are encountering in our country. It's a good example taken from Singapore. If you look into the Singapore, the judicial system is very particular. Whatever might be the dispute, exception is criminal matters. When a case is registered in the courts, first it will be referred to mediation, that to mandatory mediation. And if you look on the statistics, more than 65% of the disputes get settled. It's a good percentage and it's the greatest value for not only commercial disputes, but for all the disputes, private disputes, contractual disputes, disputes in any sector would be benefited. Next, when you look on this future, we also need to understand the outcome. A successful outcome is a settlement. Technically, it is called Mediated Settlement Agreement, MSA. And this is also mandated under the Mediation Act 2023. And this settlement can be enforced or executed. A mediated settlement agreement is enforceable and it also has the same status and scope of that of a court decree. Very interesting development, what we can see from the Mediation Act 2023. Moving further, we do have the other features like institutional mediation framework, online mediation aspects, and community mediation mechanism. These are some developments which we can encounter after the Mediation Act 2023 or the bill of 2023 was facilitated. Looking into the institutional mediation framework, it is nothing but which has a structure which creates the registration frameworks for not only the stakeholders, but essentially the facilitator, the mediator, as well as institution. The institutional mediation framework gives an opportunity for grading these institutions, as well as empaneling or before that training professionals to become mediators, and they will also be enlisted or empaneled in the panel of mediators. Several high courts across India, several district courts across India, each and every one are maintaining panel of mediators wherein we can also act as mediators in this framework. It's an excellent framework what has been brought in. The add-ons, online mediation aspect and the community mediation mechanism is balancing the development what we are encountering after COVID. The COVID pandemic during 2020, the first quarter of 2020, has facilitated for the parties, whether in the court proceedings or in the arbitration or in any proceedings, including tribunal proceedings, through virtual or online. The development, what happened during the COVID, which has a good trial tested process and most successful, except when it comes to examination of witnesses, all the processes can be handled effectively in an online platform or in virtual mode. Unfortunately, this development was not technically recognized in the arbitration legislation, but in the mediation legislation, online mediation, we do have some provisions. This is the overall understanding the future, what you have to observe. And when you deal with online mediation aspects or provisions in the Act, it explicitly anticipates as well as it also enables the hybrid and virtual mediation modes. That's very important. Down the line, 5 years or 6 years have gone from COVID. We are now comfortable with all these virtual online modes of dispute resolution, but still, as a traditional way, the effective way, we also have physical hearings. No doubt, we can have either way or both. The hybrid mode is possible. It can also go with some normal processes of the traditional way of having physical meetings. Some meetings might be in hybrid mode, might be in virtual. All aspects now is being facilitated under the Mediation Act. Explicitly, it anticipates and enables hybrid and virtual mediation modes. And the final future, what we can encounter in the mediation is community mediation. It is nothing but extending the reach, the outreach, or the capacity building of grassroots dispute resolution. A community, a society, we do have differences, but when it comes to a community, when they have some disputes, obviously those disputes can also be dealt with mediation. It can be a professional community, it can be a social community, whatever might be. That community, a dispute within that community can also be effectively resolved by mediation. And this would reach to the grassroots level, to the last citizen who is not a professional, who's not part of an organization, who's not running a business, who's just an individual having a dispute which might be a negligible amount. It can be a smallest amount, but it might be pertaining to certain rights. Those disputes need not be taken to the courts. It can very well be taken under mediation in the so-called caption heading community mediation mechanism. With all these futures, mediation is having a bright future. Dispute resolution, as I earlier mentioned, ADR, more specifically as professionals, whether lawyers or chartered accountants or company secretaries, specifically focus on arbitration and mediation. And this has become a trend wherein everyone prefers this pathway, particularly on commercial disputes. The term commercial disputes might have a wider understanding, but still, when you're trying to say commercial disputes or commercial dispute resolution, it is evident we all to bring any contract having commercial transactions. It can be finance, it can be banking, it can be a normal commercial contract, it can be a transaction, it can be an agency, it can be distributorship, it can be on IPR, intellectual property rights, everything. If there is a commercial transaction involved, that comes under the heading CDR, that is Commercial Dispute Resolution. The best preferred pathway is now arbitration and mediation. An overall definition of these two terms, we don't have a proper definition given in the law. When you take arbitration, arbitration is considered to be a quasi-judicial process. It is somewhat similar to judicial process, but still it's a quasi-judicial process where a neutral third party who is titled as arbitrator renders a decision which is binding. No doubt, it is private, time-bound, and efficient. This tribunal, that is the arbitrator who is also addressed to be tribunal, gives an award. That award is enforceable like a court decree. It is so effective when we try to arbitrate. The lighter part of this ADR mechanism is mediation. Understanding the definition of the term mediation, it is nothing but a facilitated negotiation where we can see a neutral third party. Here, that person is called as a mediator. Here it's diversified, whether it's arbitrator, mediator, it can be a male or a female or a professional. Any individual who is of sound mind can act either as an arbitrator or a mediator. The qualities expected is independence, neutrality, unbiased, and impartial. Understanding the definition of the term mediation, it is a facilitated negotiation where a neutral third party, that is a mediator, helps the disputing parties reach a mutually agreeable settlement. The process might be flexible, but still that process is confidential and uniquely positioned to preserve the business relationship, or in a simple language, the cordial relationship between the disputing parties. In arbitration, we can't just see a settlement. In arbitration, it is an award, a decision, a binding decision, which will be enforceable similar to a court decree. But in mediation, it is not a quasi-judicial process. It is just a negotiation which is being facilitated by a third party, wherein they can very well reach a mutually agreeable settlement. Which one is better? It all depends upon the choice of the parties. Here, the basic understanding for us has to start from the law, what the law says. And when we are looking into the Mediation Act 2023, it is a paradigm shift, the great shift from the traditional litigation path. As an initiative, a policy, every government's, particularly here in India, it is a central act. The government of India brought out a comprehensive mediation law by enacting this Mediation Act 2023. It is a masterpiece legislation. Every legislation has to be a masterpiece, but this is very unique because this is considered to be an alternative to the Civil Procedure Code of 1908. This is not merely an incremental change. It very well represents a fundamental restructuring of how disputes has to be resolved in India. Along with India, many other countries also has brought in mediation law, but a background of this Mediation Act 2023 is also going back to the year 2019, wherein there was a protocol which is called, or a convention which is called the Singapore Convention on Mediation, which is also called to be the UNISA, United Nations Convention on International Settlement of Disputes, settlement agreement arrived through mediation. This Singapore Convention in the year 2019, India also was the first initial signatory. And to ratify that particular convention, India has taken up seriously and they have brought in this legislation based on that particular convention, as well as the UNCITRAL, that is United Nations Commission on International Trade Laws, conciliation rules. Now, what this act accomplishes and what is the advantage, what we have. Anyway, I'll try to just come out with the opportunities, the later part, but the fundamental has to be understood in a clear manner. This act addresses two critical, we can say even a bottleneck that historically limited mediations updates or an uptake, we can say. One, uncertainty about enforcement of the mediation outcome. Before this legislation, when you look on the mediation process, we can do, there were many laws which were called ADR Act, rules, or mediation rules of institutions. But when it comes to outcome, a successful agreement, settlement agreement is also considered to be another contract, not a decision. This uncertainty of this outcome, which was considered to be a contract, which is an enforceable contract, but not an enforceable decision, has been addressed and it has been resolved after enactment of this act. Uncertainty about enforcement or enforceability of mediated settlement agreement or the outcome is now resolved. The second one, the lack of standardized professional infrastructure. There were many mediators, mediation institutions, and there were many committees formed by high courts, Supreme Court, as well as the government working on mediation, but none addressed about the basic professional standards or infrastructure, what has to be built for mediators or mediation professionals or mediation advocates. It doesn't address the mediation advocate to be only the advocate or lawyers. The parties representative before an mediation also is addressed as mediation advocates. This lack of standardized professional infrastructure is now being built, or the base has been structured in the Mediation Act 2023, wherein it can be overcome by accredited training and registries. The training is being provided in India initially in the year 2005 itself. This training has started, but it didn't have a standardized format. It was facilitated under a committee called MCPC, that is the Mediation and Conciliation Project Committee under the Supreme Court of India. This committee's role was to receive applications from interested professionals who wanted to become mediators, then train them for 40 hours assessments, provide them with mediation cases for 2 years, acting as a pro bono professionals, and finally qualifying them to be mediators. This was a process by MCPC, and these mediators were facilitating the court annexed mediation cases. This court annexed mediation cases is nothing but evolution from CPC the year 2000 and 2002 it got into force. Section 89 was included in the Civil Procedure Code, which is the basis procedural law for any disputes in India, whether in the courts or the tribunals. We have to follow the CPC. Section 89 was included in the CPC in the year 2000, which came into force on 2002, which clearly says a pending case before a judicial authority or in the courts can be referred if the judge or the judicial authority finds there is an element of settlement to refer to either mediation or arbitration or judicial settlement or even Lok Adalat. The last two is not much significant because Lok Adalat we have some pecuniary limit of 10 lakhs and below can be referred. So small claims can be referred. Judicial settlement is all evolved by different law. Both Lok Adalat and judicial settlement, we had to rely on the Legal Services Authority Act 1987. But the first two, arbitration and mediation, is much, much developed, and the court-annexed mediation got a great response from all the judicial authority, whether it's a district level or the state level or even the national level. They started referring the matters to ADR mechanisms. This legal scaffolding obviously moves mediation from good practice to a recognized one. Not only recognized, enforceable dispute resolution pathway. This Act, Mediation Act, several provisions are there. I'm not just going to all these provisions. You can just have a good reading whenever you find time. It has a lot of aspects bifurcated. Not only this community mediation, online mediation, pre-institutional mediation, institutional mediation. We have the process. There are even provisions states that which cannot be referred to mediation, which disputes cannot be referred, and what might be the role of institutions, what would be the effect of the mediated settlement agreement, how to enforce it, and what are the mechanisms to challenge even that settlement agreement. All has been perfectly categorized in that Mediation Act. Now we got the tooth. The good practice is being recognized, enforced as a dispute resolution effective pathway. In my understanding, personally, this act substantially lowers transaction cost as well as legal risk for parties choosing mediated settlement. The disputes can be settled. The disputes can be amicably settled except certain disputes. That's a very less percentage. You can technically mention hardly 2 to 5% might be controversial or high value or complex disputes, which cannot be resolved amicably. Most of the disputes, more than 95% of the disputes which comes to the courts are very, very basic, egocentric, and doesn't has a value to be continued. If you opt for mediation based on this legislation, it substantially lowers transaction cost and legal risk for parties choosing that option. This is considered to be, as legal professional, as a paradigm shift from the traditional litigation. Coming to the arbitration framework for another few minutes. Most of you would have already gone through this Arbitration Conciliation Act, which is quite old, 1996. Now, 30 years have gone. And this legislation also has seen 3 amendments. One in 2015, the second one in 2019, and the third one in 2021. And in 2024, there was a bill which is pending as consultation paper. This legislation, Arbitration Conciliation Act, governs arbitration in India. And this legislation also came from a background of ancestral model law, the year 1985, and more than 100 countries, mostly developing countries as well as underdeveloped countries, have adopted this model law in their national legislations, arbitration law, the national laws. This act also is a central act. Here, When you look on this law, specifically, there is one provision, section 26, which speaks about appointment of expert by arbitral tribunal. Here comes the opportunity to most of the professionals. This particular section 26 explicitly empowers the arbitrators to appoint experts to report on specific issues. Sometimes the experts themselves also can be appointed as an arbitrator. In that way, it's so comfortable. That is very well given in section 11 of this act. Anyone can be appointed. In that way, the parties wants to have technical persons to be appointed, they can be appointed as arbitrators. But this explicit power given to the arbitrators to appoint expert to provide a report on certain issues gives a wider opportunity. This is the framework what we can come across in arbitration. It is also aligned with international standards. When we saw mediation, we were looking into the Singapore Convention. And when we are looking into arbitration, it is much more popular and aligned with international standards because UN Commission on International Trade Law has recommended, and most of the jurisdiction has adopted this principle. And cross-border also is so convenient, not only domestic, international cases also so effectively resolved through arbitration. When you look on these recent amendments, in addition to this section 26, which has introduced particularly the 2015 amendment, which has introduced schedules, which is making the arbitrators accountable on their moral and ethical responsibilities, like specifying their grounds for justifiable doubts about their independence and impartiality, has raised the standard of the process and increasingly being extended to experts as well. There are some 3 schedules included, that is 5th schedule, 6th schedule, and 7th schedule in the arbitration legislation, wherein a big list of categories of relationship is expected to be disclosed by the arbitrator at the time of seeking the appointment or at the time of being appointed. This clearly limits the party's vulnerability on choosing an arbitrator who is not independent. An arbitrator is expected to give a disclosure not only pertaining to the parties. The arbitrator is expected to give disclosure regarding the dispute, regarding the representative of the parties in the dispute, regarding the affiliate of the parties in the dispute, regarding close family members of the parties in that dispute. It's like 360-degree scope given for the arbitrator when it comes to disclosure before even taking the role of an arbitrator in that particular dispute. A person who is immune from any relationship would be preferred as an arbitrator. In that way, the standard has increased, and it is also taken up for experts who have been appointed under section 26 by the arbitral tribunal or the arbitrator. Now comes the core element. What is the demand we have? The market demand, and we can also try to understand the percentage of the numbers, how it's mentioning the actual reality of the opportunities. There are many institutions, the states, that is the countries, as well as the provinces or the states within that countries, institutional mediation centers or institutions, which have been already reporting thousands of mediated cases in an annual basis, With many centers achieving, you can say the settlements rates are quite higher, or sometimes even it exceeds the court's timelines for resolutions in some cases. As a consolidated annual statistics from many of these existing state mediation centers, which are nothing but mediation institutes or mediation service providers. In the Mediation Act, you can see two things. One is MI, which is called Mediation Institute. Another one is called MSP, which is Mediated Service or Mediation Service Providers. The existing MSPs or MIs are nothing but the court-annexed mediation centers. Every high court has a mediation and conciliation center. These are all considered to be the state mediation centers, which reflects a significant volumes of cases and meaningful settlement ratios. That's very important. Since 2005, initially it was started in the state of Gujarat, attached with the High Court of Gujarat, then Madras High Court, and now every high courts across India has mediation centers. The market demand has increased. The ratio of settlement has also increased. But when you come to the supply side, in the perspective of chartered accountants, it's all market driven. The demand is high. But when it comes to supply side, the qualified mediators as well as the institutional capacity remains even now a limited factor. Surveys and expert voices within, when you look into the Indian ADR ecosystem, often calls for huge or large-scale investments on accredited mediators training as well as registries. There is a huge variation in the demand and supply. The demand is high, but there is a shortage in supply. We have people to mediate, but those are not coming within the category of accredited mediators or qualified mediators. We do have institutions, but unfortunately, the capacity of those institutions is not to that expectation to handle so effectively and resolve the issues at the earliest possible time. This clearly shows, not only for lawyers, it's for chartered accountants also, a gap which represents opportunity. It is a gap, big gap. We have to try to balance. Demand and supply has to balance, and chartered accountants, they have to take this as the greatest opportunity. Get yourself trained as mediators in any of the arbitration mediation institutes. You have, I'll come to your arbitration institute also, which is also called an ADR center of chartered accountants. But as of now, there are multiple opportunities. Many institutions are operating across India. Get yourselves accredited with these trainings, enter into these registers, get involved in actual mediations, and the demand supply difference would be minimized. What is the advantage? Chartered accountants' advantage here. The fundamental proportion what we can look upon when it comes to the opportunities or the advantage what chartered accountants have. Most of the commercial disputes boil down to one thing. It's about money or claim. Every litigations in the courts or in the arbitration or mediation mostly end up in money claims. Establishing rights are there. It might be constitutional right, which might have a different platform to be resolved. But most commercial disputes have one common understanding. It is about money claim, monetary claim. A dispute over a contract is usually a dispute over financial implication. And the loss, like example, we can say loss of profit, loss in opportunity, breach of warranty, valuation of shares, accounting irregularities, damage quantification. The list goes on. These are some financial implications. Whether it is going to be loss of profit, whether it's going to be breach of warranty, whether it's going to be on valuation of shares, whether it's going to be on accounting irregularities, all these have some financial implications. Here, as a lawyer, I'll try to argue the law stating that a chartered accountant understands the numbers. No doubt. Lawyers are not so comfortable in numbers, but chartered accountants can understand numbers. Very, very important. There is one, when I was just doing some research, I could find one legal expert in his very famous note in quotes, technical matters on which only professionals can give a sound opinion. And he took an example of a chartered accountant wherein the books of accounts required to be gone into such professional assistance of technical experts can be sought by arbitral tribunal or the arbitrators. A legal expert wanted to have a chartered accountant who can very well understand the books of accounts as a professional assistance of technical expertise for an arbitrator or an arbitral tribunal. Chartered accountants can understand numbers. Lawyers are not to that level. There might be some professionals who are multi-qualified. They can be a lawyer and chartered accountant as well as company secretary. They have multiple qualifications. That's a different perspective. That will be an exception. But exclusive chartered accountants are considered to be experts in understanding the numbers. With that particular code, this we have to take it as a serious, a fundamental proportion, what a chartered accountant has an advantage over a legal professionals when it comes to arbitrating monetary disputes or monetary claims or money claims. There might be also some situation wherein chartered accountants are considered to be unique or having a unique value. We can just separate arbitration mediation considering the uniqueness or the quality of that professional to be considered utmost priority. In arbitration, disputes like partnership disputes, shareholder disputes, construction disputes, insurance claims, forensic accounting issues. These are quite taken up in arbitration. In mediation, we can try to categorize family, business succession disputes, commercial contracts, renegotiations, taxation disputes that can be mediated, regulatory compliance conflicts that can also be mediated with some limitations. Disputes initially like partnership dispute, shareholders dispute, construction disputes, insurance claims, forensic accounting. Chartered accountants have a better say in the arbitration process. For example, when you take partnership disputes, in partnership disputes, there is a high requirement for financial unraveling. It's very quite vulnerable on the expectations on the financial unraveling. When you have this shareholder disputes, there is possibility or requirement of valuation expertise. A chartered accountant is the best person, a financial valuer of those shares. There might be some company secretary also at part of that, but these are all unique value a chartered accountant possesses, particularly in such disputes in arbitration. When you take up this construction contract disputes, here there is delay damage quantification. Every construction contract disputes would be on delays. 12 months, 36 months, 48 months to complete a construction project. Most of the contract they couldn't complete because of various reasons. Monsoons, shortage of supply of raw materials, escalation of cost of steels and other materials. There can also be vulnerability on variations on the designs. But all leads to delay. And the delay damage quantification, each day of delay, each week of delay, each month of delay, leads to a calculation which is all on a monetary claim, which has to be quantified. A best person to effectively quantify is a chartered accountant. A chartered accountant is the best person to have the delay damage quantification done in a proper manner, how to effectively resolve the disputes. Coming to the insurance claims, a common aspect is loss assessment. What loss they have incurred, whether it's pertaining to marine, whether it's pertaining to health, whether it's pertaining to professional negligence, whatever might be. The loss assessment, a chartered accountant is a better professional to deal with such disputes in arbitration, whether as an arbitrator or as an expert before the arbitrator or appointed by the arbitrator tribunal. And when we're dealing with forensic accounting investigations, every forensic accounting investigation can be done only by a chartered accountant, not by any other professionals. These are some unique qualities a chartered accountant possesses in arbitration, and this is a wonderful opportunity on these type of disputes. When you take up mediation, as I earlier mentioned, the family business succession disputes. There are many families who have joint businesses, family-run offices, not as partners, as family members, they usually do group companies. If any disputes on the succession of these family issues comes, a chartered accountant who is a well-wisher to all the family members, who knows the value of that family, who knows the value of that business, who also deals with the accounting, day-to-day accounting of that particular business, would be the right person to get involved, particularly through mediation. Commercial contract negotiation, there is a possibility so effectively chartered accountant can negotiate on behalf of the parties, or particularly when it comes to renegotiation, it's a facilitated negotiation happening in mediation. The chartered accountants can be the best person to deal with it. Taxation disputes is an exclusive domain of chartered accountants, or highly rated opportunities given to chartered accountants. That can also be taken to mediation, wherein a chartered accountants can get involved. Regulatory compliance conflicts with some limitation, chartered accountants can also have a constructive role. Moving ahead, I wanted to just go back to one aspect which I earlier mentioned about Section 26, that is the legal recognitions of the CA's role, or experts, CA acting as expert appointed by arbitrators. This particular provision, which in courts states that unless otherwise agreed by the parties, the arbitrator may appoint one or more expert to report to it on specific issues to be determined by the arbitral tribunal, and require a party to give the expert any relevant information, or to produce or to provide access to any relevant documents, goods, or other property for his or her inspection. This is what earlier I was mentioning, but this is the abstract of that particular section 26, specifically subsection 1. But here, additionally, what I found from your regulations, particularly the section 2, subsection 2, 4, if I kindly just clarify it by using the chat box, wherein this particular provision of the Chartered Accountants Act of 1949 specifically allows a chartered accountant to act as arbitrator in their professional capacity. Section 2, subsection 2, 4 of the Chartered Accountants Act. And there are multiple regulations across many jurisdictions. The Chartered Accountants Regulations 1988. I'm not just going to that in too much, but it permits a chartered accountant also can act as arbitrator as well as expert before arbitral tribunal. At this point, there is also some professionals, chartered accountants, who I have been acquainted for a longer period. They are already doing this role. They are so effectively dealing with these roles. Without disclosing the names of those professionals, I'll try to share as inspirations, a good example for chartered accountants who have built successful careers in this space. Most of them are now fellows after reasonable experience. One chartered accountant who's actually now partnering in a particular MNC firm. He specializes in disputes and crisis work. He has been involved in the preparation, coordination of numerous expert witness reports for many ad hoc arbitrations. In one also, I had an opportunity for the gentleman who has prepared expert reports, wherein he was brought in as an expert witness. And also under many of the prominent arbitration institutions like the Singapore International Arbitration Center, the International Chamber of Commerce Court of Arbitration, and the oldest one, the London Court of International Arbitration. All these forums, he happened to be expert witness. He is not stopping there also. I found out that Beyond whatever I have experienced, his work includes expert reports for loss of profit claims, valuation of buyback shares, and damage assessments across sectors, including, we can say, sectors like defense, automobile sector, the retail sector, the infrastructure, the list goes on. A wonderful thing what a chartered accountant is already doing. Another gentleman, a chartered accountant by basic professions, acting as independent arbitrator, and his specialty is something unique. He is dealing with investment treaty arbitration, investor state arbitration, maritime disputes. It's a different thing what he is doing, but he has a core understanding of disputes. He also has some background of more than 10 years of M&A industry experience, mergers and acquisitions. That's a practical. He was an employee earlier with his basic qualification of a chartered accountant. He is acting predominantly as arbitrator. The earlier gentleman was dealing the role of experts, being expert witnesses in many arbitrations, domestic as well as international. And another gentleman also who I just come across, who's also qualified chartered accountant, but he's not a fellow right now. He's just an associate at the beginning level. He's specialized in civil litigation with particular interest in contentious insolvency, fraud, as well as asset tracing. Here, this gentleman is assisting expert witnesses in a very large claim. And there is some groups like a body called ICAEW. It's about forensic and expert witnesses group, wherein he is part of it. ICAEW, forensic and expert witness group. And based on that, he is assisting expert witnesses in multi-billion arbitration disputes. This is just an outline of what I found in my practical work acting as arbitrator and getting involved as co-arbitrators with chartered accountants in many of these jurisdictions. Okay, now comes the professional pathways for chartered accountants. We have to no doubt explore all these specific roles, what I just highlighted with these real-time example of 3 chartered accountants. The specific roles a chartered accountant can play in arbitration and mediation. This is no doubt not mutually exclusive. Many practitioners might transit through multiple roles during their careers, but in my understanding, I can just very well say with all these 4 pathways. The first pathway, you can say a chartered accountant can be the best arbitrator. It now comes the question, what an arbitrator would do. A simple understanding is that as an arbitrator, you or me or the judge, when you take up that role, we are the judge. You have to hear the parties. You are going to examine the evidences. And finally, you are going to pass an judgment, which is termed as award, which is legally binding and enforceable, like a court decree, which I highlighted earlier. Here, you are going to, that is, the arbitrator has to control the proceedings, have to determine questions of law and fact, and also deliver a reasoned decision. A reason speaking award has to be given. These are the thumb principle of an arbitrator's role in an arbitration process, or a simple understanding of what does an arbitrator do. Here, I just found some aspect of where do chartered accountants fit. I gave a big list of disputes, but the best ideal suited disputes are where an arbitrator role can be taken by chartered accountant. Valuation of assets and business, shareholding and partnership disputes, computation of damages and insurance claims, auditing related negligence claims, taxation disputes, and financial contract implications. These are quite ideally suited for chartered accountants. The chartered accountants who have already that qualification can handle so effectively the disputes which I highlighted as an arbitrator. But here, what are the other value additions or some add-ons what you have to do to be a better arbitrator, better person to handle that particular role? There are qualifications and empanelment. In India, for major bodies like we can say the Indian Council of Arbitration, which is the very oldest arbitration institution, I think in the year 1965 it was established. It clearly mentioned typically 15 years of post-professional experience for any professionals to be included in their panel of arbitrators. Post-professional qualification, 15 years. And when we take on your own institute, ICAI, it is based on a course entry points availability. ICAI was created recently, the last quarter of 2025. But before that, for the past more than 1 decade, Institute of Chartered Accountants have done multiple certificate courses on ADR as well as arbitration and mediation. And people who have successfully completed those courses also makes up some entry points to get into the panel of ICAI. This ICAI International ADR Center is creating or planning to create a structured pathways for members from the Chartered Accountants community. It's an exclusive body. What is expected from all of you or to take up this opportunity? We do have to take this opportunity in so constructive manner. What is expected of you? There is a say when I actually started as an arbitrator, as one arbitration expert who has quoted quite clearly. The expert is required to observe procedural rules, or we can say adhere to the due process, and is entrusted with the duty to act in good faith. We have to be very cautious. The apex court in the country, that is the Honorable Supreme Court of India, has recognized that violation of principle of natural justice, including lack of independence or impartiality, becomes valid ground to set aside an arbitral award. This is a thumb rule is expected from any professionals who are going to act as arbitrators. What is the independence or the standard of independence expected in arbitration? For tribunal, For tribunal appointed experts, it is the same standard. The standard of independence should be the same that of an arbitrator. And in the India International Arbitration Center, which is another body called IAAC, the regulations of 2023 makes it a mandatory aspect for an appointed expert to provide a declaration that they are and shall continue to be impartial and independent. This is all expected from a chartered accountant who is inclined to act as an arbitrator. If you want to act as an arbitrator, the basic principle is not to violate the principle of natural justice. We should be independent and impartial, and the various regulations of arbitration institution also gives a guideline that this expert reports or the experts who are going to act coming from various disciplines have to provide declaration which makes them independent and impartial. This is for the role of an arbitrator. Moving to the second pathway, a mediator or a conciliator. Here also we have to understand what does a mediator do. Unlike an arbitrator who decides, a mediator facilitates disputes resolution. If you are going to act as a mediator, your role is to help parties communicate, understand each other's interest, and arrive at a win-win situation. In mediation, it is all about win-win. In mediation, you acting as a mediator is not going to give a decision. You're going to be a facilitator. You're going to be an evaluator. You are going to take the probabilities from the parties and come with a win-win solution, recommendations for an amicable settlement. You are not imposing a decision. You are guiding the parties to their own resolution. That is, there is a principle called principle of objectivity. Your object is to lead to amicable resolution. Bring the parties to a common ground and try to settle. You are not going to impose decision. Here, similar to an arbitrator's role, why CAs may exceptionally be a good mediator. As my personal understanding, there are 3 to 4 exclusive points what I wanted to highlight, making CAs as exceptional mediators. The first one is financial acumen. In disputes involving business valuation, the diverse assessment, or even a commercial contract, parties need a mediator who understands the numbers without being overwhelmed by them. The financial acumen is the greatest advantage what a chartered accountant has. Next, they have the trust and integrity. Major family businesses run offices. The trust is given on the chartered accountants to deal with all type of financial issues within the family or within the business. The trust and integrity, which is the ethical principles of integrity and objectivity, which a chartered accountant adhere to build. Immediate trust, or it is going to build trust with the disputing parties. Meeting the Third comes regulatory navigation. The chartered accountants can help parties navigate complex regulatory landscape to ensure their settlement is in compliance. And finally, in my understanding, it can also be analytical rigor, what the ability to analyze complex situations and identifying underlying interests, which is the core to both accounting and mediation. The chartered accountants are the best professionals. Moving ahead with the Mediation Act. The Mediation Act 2023 is creating immediate demand for chartered accountants taking the role of mediator. As I earlier mentioned, pre-litigation mediation mandates qualified or requires qualified mediators. The courts are diverting suitable matters to mediation at an unprecedented scale. Institutional mediation centers needs accredited professionals. These are some immediate demands created under the Mediation Act 2023. Here, there is also a complement for cost accountants. Some of you also might be cost accountant. It is also equally significant, wherein commercial disputes are best resolved through mediation. As earlier mentioned, they also require technical expertise and professional approach. And here, the cost accountant are best equipped to analyze commercial disputes. Mediation may be looked as the only avenue of professional growth and as a way to help businesses and consumers by freeing up the time and money that would otherwise be locked in disputes. The same thing applies for chartered accountants and vice versa. The first pathway as arbitrator, second pathway as mediator, now the third pathway, expert witness or financial advisor. What does an expert witness do? Even if you are not the arbitrator or mediator, it's not that always you'll get that opportunity. There is immense opportunity in assisting the arbitrator or the advocates representing the parties in arbitration. You as chartered accountants are going to provide specialized opinions on evidence or on facts in the issue between the parties. The parties can also appoint you as their own experts, and they can just facilitate the expert reports on their behalf. The arbiter tribunal also, as earlier mentioned under Section 26 of the Arbitration Conciliation Act, can also facilitate. Where these experts are needed, when this requirement arises. There are many studies. A common study outcome found that the companies normally use experts in matters relating to a certain percentage, to the level of even 25% for valuation, less than 20% and below for accounting, and for industry-specific areas like financial services, construction, engineering, oil and gas, is even above 40%. Okay. Now, when it comes to types of expert work, what as a third pathway, an opportunity for chartered accountants, you can be engaged as a quantum expert, valuation expert, forensic expert, and accounting expert. When you take the first one, quantum expert, it is nothing but a quantified financial or quantification of financial loss or damages. Like example, we can take up the breach of contract damages. It's just quantification of financial loss or damages, which cannot be done by legal professionals or any other professionals. Chartered accountants are the best quantum expert. The second one, valuation expert, it is about determining the fair value. Most of the time in shareholders buyout disputes, we can encounter this. A fair value has to be determined. Third one, the forensic expert. It is nothing but it is about investigating fraud or irregularities. The financial misappropriations can be investigated. That can be done by forensic expert. Good opportunity is there. And the final one, accounting expert. It interprets like the accounting principles, wherein the revenue recognition disputes can be handled. Quantum expert, valuation expert, forensic expert, and accounting expert. This is few opportunities. But when you look on this expert's role in real-time arbitrations, the experts are going to prepare the expert reports for arbitration forums or the institutions. It can be for participation in experts hot tubbing, that is concurrent expert evidence, having more than one expert evidences how to hot tubs. And it can also be involving damage assessment across sectors. But here, a simple vulnerability is there. When you are going to act as expert and going to provide a report, you might be subjected to examination, that is cross-examination by the counterparty or the counterparty's representative, or sometimes with the parties against the arbitral tribunal's expert. And there is a very interesting provision in section 26 itself. In subsection 2, it says, if a party so request, or if the arbitral tribunal considers it necessary, the expert shall, after delivery of his written or oral report, participate in an oral hearing where the parties have the opportunity to put question on him. That is just examination, cross-examination of that particular witness. Your report, it is your report. You have to withstand the scrutiny of it. You have to face it. That is very, very essential. Moving ahead, the fourth pathway. What is the fourth pathway? We saw arbitrator, we saw mediator, we saw expert. The fourth pathway is parties representative, or sometimes you can also act as counsel or advocate for parties before arbitrators. There is a great question. Can a chartered accountant represent a party in arbitration? Very well, you can. You can act as party in arbitration. Traditionally, it is considered to be the domain of lawyers, but nothing in the arbitration law prevents a party from being represented by a non-lawyer. When you look on a provision in the Arbitration and Conciliation Act, there is Section 6, which provides that to facilitate the conduct of the arbitral proceedings, the parties may arrange for administrative assistance either by a suitable institution or person. A person is nothing but the person's representative in the arbitral proceedings. There is no restriction for a chartered accountant or any other professionals to represent party in an arbitration proceedings. Being such a situation, what is the advantage of having chartered accountants as representatives or parties counsel before the arbitral tribunal? The chartered accountants have deep understanding of the party or the client's businesses and their financials, which a lawyer lacks. The chartered accountants might have the ability to prepare the statement of claims with financial precision. The lawyers might lack. The chartered accountants would have the skill in drafting and arbitration clauses in contracts. Most of the time in partnership deeds, they are the best person. And when you can also stretch to that level, chartered accountants have the capacity to argue the financial aspects of that particular case so effectively. These are some greatest advantage entrusted to chartered accountants. They can very well understand, deep understanding of the client's businesses and financial. They have the ability to prepare the statement of claim with financial precision. They have the skill even to draft the arbitration clauses in the contract, and they have the capacity to argue the financial aspects of cases so effectively. This, in a personal note, I find to be an emerging opportunity, particularly in domestic arbitrations, where the parties seek cost-effective representation from someone who truly understands their business. A person who is part of the business, particularly understanding the business, would be the right person to represent before an arbitral tribunal. These are the 4 pathways what you all have as a greatest opportunity. Now comes how you are going to build your ADR practice. What might be the roadmap? When it comes to roadmap, unfortunately, we also have to look upon the aspect of some essentiality, which is quite significant. What has to be built up? What is so essential? Technical accounting expertise alone is insufficient. To succeed in ADR, you have to succeed in ADR, you must develop a certain skill set. The skill domain we can say is that legal literacy, communication, report writing, negotiation, impartiality, cross-cultural competence. These are some skill domain, what I got out of the research on chartered accountants to be so efficient beyond their technical accounting expertise. When you look on the legal literacy, the competency, what specifically interested or might be required is that an acumen on the Arbitration Conciliation Act 1996, the Mediation Act 2023, the Basic Contract Laws, Indian Contract Act of 1872, and some evidence principles, the earlier Indian Evidence Act of 1872 and the present BSA 2023. It has been rechristened as BSA 2023. These are some legal literacy, specific competencies required on legal literacy. When it comes to communication, we have to be an active listener, better questions on techniques, build up rapport. Active listening, questioning techniques, as well as rapport building is so essential competency under communication. As a writing or report writing skill, the competencies are clear, logical, defensible expert reports. Nothing beyond that. Negotiation skill. That's a key advantage what a chartered accountant has. But as a competency, try to just build interest-based bargaining. And we call consensus building, that is consensus ad item, a mutual, amicable category of resolving the disputes. It has to be interest-based bargaining and consensus building. Moving to the impartiality as a skill domain, the competency is neutrality, conflict of interest identification, and disclosure. The conflict of interest is much which has to be understood on the disclosure, what we are going to make based on the schedules of the Arbitration Conciliation Act as well as the schedule of the Mediation Act 2023. Cross-cultural competency, what required is nothing but you have to develop international arbitration contexts, nothing more. We have to be prepared to understand and analyze various countries' legal principles or accounting principles or other skills. Now, when you are just prepared, building your ADR practice, taking into these essential skill set, there are some initiative done by ICAI. ICAI, that is your institute, Institute of Chartered Accountants of India, has strategically positioned itself in this place. As I earlier mentioned, the ICAI International ADR Center. It is also IIAC. ICAI International ADR Center. It is established as a Section 8 company. This center aims to provide transparency, technology-enabled, and globally benchmarked dispute resolution services. No doubt, this center, similar to other valuable centers for excellence, is also setting up its center across India through its branch network, creating a structural pipeline for chartered accountants to get empaneled and appointed as arbitrators and mediators. They are having their own panel of arbitrators and mediators. You can just get yourselves involved in it, subject to what are the criteria they are going to provide. On the certificate course of for arbitrators, Chartered Accountants Institute has developed comprehensive courses understanding the basic law, which is a skill set, which I just earlier highlighted. Arbitration Conciliation Act familiarity, ancestral model law of 1985, the jurisdictional aspects in arbitration, the relevant provisions on allied laws, not only the Arbitration Conciliation Act, but the Indian Contract Act, the Partnership Act, the Negotiable Instruments Act, the Information Technology Act. Then we have intellectual property rights related acts. We also get to understand the provisions of Securities Contract Regulations Acts. It goes on the list. Multiple allied laws is being taught. It also speaks about code of ethics for arbitrators, drafting of arbitration clauses and awards, as well as post-award issues. Multiple aspect is being covered in the course so that it makes you eligible to be included in the panel of arbitrators to move forward, and that is facilitated by your institute, the ICAI. Earlier, through these courses, now with the ICAI International Arbitration Center also is making it across the country. Okay, what as a step-by-step action plan, what we can have as chartered accountant, opportunities there, how to reach. The first step always in anything, get trained. Second step as a step is get certified and accredited. Third, get empaneled. Fourth, start small and reasonable network. 5, build a niche. Like any other professional domain, first get trained. Get yourselves enrolled in ICA certificate course. It's just a part. This is one. But since all of you are chartered accountants, always better. Many of you would have already done. For them, it is not to be repeated. You can just go to the other steps. But for beginners, get yourself enrolled in these courses. Pursue the mediation training from recognized institutions like the MCPC or the Indian Institution of Arbitrations and Mediations, Kuwait Foundation, Conflict Resolution International, KFCRA. There are many institutions which provides training. Consider specialized programs even in forensic accounting evaluation. Get trained yourself in all these, whatever available. Once you complete the training, you will get into certifications and accreditations. Completing ICA course of certifications, registering with mediators or mediation registries under the Mediation Act framework, getting into multiple institute which offers structured mediation certification programs, producing practitioners skilled in both facilitative as well as cross-cultural context. Many are there. Get trained, get certified, and accreditation. This the initial steps. With experience also straight away and go, but these are some probabilities. Next, get empaneled. The first possible empanelment can happen in your own institute, ICAI International ADR Center. The requirements are very simple: course completion and experience. It is your own institution. You are the best person to be considered in it. And we do have institutions like Indian Council of Arbitration, as I earlier mentioned, the 15 years threshold of experience post professional qualification experience. This we can consider to be alternative categories which is in existence. We have even the state mediation centers attached to the high courts. They will provide the mediation training, and there is a huge demand for it. explore that. And beyond borders, beyond our country, go to international arbitrations and mediation institutions and centers. Get the specialized expertise so that you will become advanced practitioners. This is very much required, getting empaneled in these centers, whether arbitrations or mediation centers, domestic or international forums. Based on their experience, post-qualification experience, the trainings, you will be inducted or empaneled. Moving ahead, we can also start small networking, small networks like do voluntary pro bono mediation services. Beginning with, not later with your experience. If you have vast experience, don't do pro bono. But to reach effectively with that market, getting that opportunity, demand is there, but reaching that demand with all what you have gained. Volunteer to some extent for pro bono mediation service. Accept appointment as party appointed arbitrator in small disputes. In 3-member tribunal, the claimant and respondent initially would nominate, and the third one has to be independent, technically. Network with law firms and corporate legal departments. Small networking. It's a legalized process without soliciting. Make yourself available within the lawyers community as expert witnesses, a person who can be a best expert, who can prepare the report as well as be a witness. Consider joining associations like what I mentioned, ICAEW, Forensic and Expert Witness Group. These are some startups, small networking build-up. We can also go for specialization, which allows to command higher fees, like we can say the taxation disputes, super specialty, taxation disputes, construction and engineering claims, family business succession, mergers and acquisition disputes, forensic investigations are quite high value, but a super specialty is required so that you can exclusively get into this market. But no doubt, there is a great financial upside, wherein as arbitrator, if you can take on Indian Council of Arbitration, like a income tax slab they are given, if the dispute amount is to the extent of 5 lakhs, the arbitrator fee, one arbitrator, he is entitled to the maximum of 60,000. For disputes between 5 lakh to 25 lakhs, even 1.25 lakhs can be the fees. For above 25 lakhs to 1 crore, an arbitrator fees is to the level of 2.5 lakhs. 2.5%, very simple. It's a good fees. This arbitrator fee, what you can get. This is just what I have taken from the institute, the arbitration institution. Every institution differs. Just have a good analysis of that. It's always a good opportunity as an arbitrator. As an expert also, international practitioners work on disputes valued at millions of dollars. Here the fees are quite significantly high than the traditional auditing fees, what you get. There are good examples of chartered accountants who have assisted as expert witnesses in high value claims, wherein their fees also really higher than the traditional auditing fees. As mediators, it's all about case to case, case by sessions, or case by that particular claim amount. It can be on hourly basis, or it can be on a lump sum. It is not on contingency, no doubt. If it is on contingency, it's a different perspective. It is not happening in mediation as well as in arbitration. It's based on the workable hours, the professional hours you are going to spend. It also increases with the reputation as well as the successful rate. Here, the recurring referrals from satisfied parties is your growth. you'll get multiple mediations once you have a good success rate. As a practitioner for more than 2.5 decades in ADR work builds your profile. It leads to corporate referrals and also position you as a trusted advisor beyond compliance. Whether it is going to be a shareholder dispute, wherein there will be multiple questions for the parties. Why would the parties choose a chartered accountant as an arbitrator than a retired judge or a legal professional? What specific financial expertise would be relevant? What independent consideration must the chartered accountants as an arbitrator should address? How the chartered accountant can handle valuation methodology disputes. Multiple queries might come, or similar when you go to a mediation aspect. As a mediator, how this chartered accountant would leverage the understanding of their interdependent financial interest. What confidentiality or considerations apply looking into the laws, the prevailing laws in India or outside India, depending upon it's a cross-border or a domestic dispute. How you're going to structure the mediation process. What creative settlement options might be coming forward from a chartered accountant. All these would add the greatest opportunity for you to explore to be a good pathway leader in the ADR mechanism as arbitrator, as mediator, as experts, or any role, even counsels, advocates before the arbitral tribunal. Friends, the world of dispute resolution is no longer the exclusive domain of legal professional. I have to confess. The complexity of the modern commerce demands decision makers and facilitators understand the language of business, which is most interesting in the language of finance, where chartered accountants sue. The laying down the foundation of institute like ICAI with its already certificate course, the initiative by the government bringing in the Mediation Act 2023 are all making you to be in a better position in any role in disputes and dispute resolution. Here, the opportunities reached the ripe for the picking. I personally urge all of you to look at arbitration and mediation not as a hobby or a part-time assignment or a retirement plan, but as a core part of your professional, or even you can say as a portfolio. It is challenging, no doubt, intellectually stimulating, but it will financially reward. And the greatest satisfaction is that you are going to be even a judge, a private judge, and you are going to resolve the dispute amicably or by decision, depending upon whether it's mediation or arbitration. And the greatest satisfaction is that you are going to resolve the dispute between two individuals or an entity. Explore your actions immediately. Whether it is the certificate course on arbitration, look into it. Do the research on mediation training programs. Identify the potential niche like taxation, valuation, construction, family business. The simple final word, what I wanted to say is that start networking with dispute resolution professionals. And it is the time for chartered accountants to step up and deliver the quantum of justice. Thank you. Thank you for patiently hearing. If any questions, you can very well put forward in the chat box.
So there was one question. Basically, currently, you might be aware that there is a case between advocates and chartered accountants who can represent in tribunal or who can represent in these cases. So, what will you say about the same? What is your take about the same?
No,
It's my
here
personal question.
it is not only pertaining to chartered accountants and lawyers who are already appearing in multiple forums and courts. Chartered accountants, to some extent, are restricted when it comes to courts, a normal under the civil procedure. But in arbitration, whether it's domestic or international or in mediation, there is no restriction, not only for these professionals, but for any professionals. This is not a domain which is called a justice delivery system. You got it?
Yes, I got it. So, any other question? We can conclude. So, we'll wait for 5 minutes for questions.
Yes, yes.
Well, there are no questions. So, we'll now move to we'll now end the webinar. Thank you so much, sir, for sharing your valuable insights, including how arbitration and mediation are important for chartered accountants, how they have to see through this mediation and arbitration, and what are the opportunities in the same, um, and even for providing us the practical guidance on the same. And I am sure that today's session has helped all of us to understand the growing opportunities for chartered accountants in the field of dispute resolution and ADR mechanisms. On behalf of Commercial Law, Economic Advisory and NPO Corporative Committee of ICAI, I extend our heartfelt thanks to you and all the members who have joined the webinar and all the and making a meaningful learning experience. Thank you, everyone.
Thank you. Thank you.